Chris Chapman, and I live in Cocoa. And by trade, I'm a swimming pool contractor. Now, the definition of trade is not defined. I'm not using that definition as you find in the Internal Revenue Code. But how I got started in this was back in 1989, while I was in Cocoa, operating my swimming pool business. I went down to Fort Lauderdale, where I lived for 20 years, or more than 20 years. I went down to visit a friend. And I hadn't seen him for a while, so when I went in there, we sat down, we had some coffee and everything, and he was telling me about a program called the Pilot something. Marsh was the guy, I think a few of you old-timers will know Phil Marsh, that later went to prison, but he had a pilot program which had talked about the Internal Revenue taxes. And he was raising his right hand and said, I'm an alien to that nation. Well, this was totally off the wall with me. I didn't know anything about aliens or anything. As far as I knew about the Declaration of Independence, there was always pictures of guys wearing wigs. And, you know, in the Declaration of Independence, you know, I never paid much attention to it. It's not something like we studied in detail. So I started talking about jurisdictions and how the IRS code didn't apply to him and all that. And in the meantime, I was going through an audit with my company because my bookkeeper didn't pay the IRS taxes like she should have. So I said to my buddy Rod, I said, well, that's fine. One day I'll be getting you out of jail. And I said, you're nuts. You got to pay the IRS. You got to pay your taxes. That's what the company was running on. And he tried to explain it and everything, but he was giving me too much information. So within, I don't know, about 6 months or so, there was a tape that was put out about the money system and the IRS. And it was done by a very well speaker. I can't think of his name now, Friedman, something named Friedman. But, and I had to pull over on the side of the highway and listen to this tape. This tape was so good, it explained the Federal Reserve System, it explained the IRS, it explained about the revolution, and so forth. And I sat there on the side of the road, and tears were literally coming out of my eyes. I realized what Rod was talking about. It started to come together. Well, at that time, you know, the internet wasn't available, and also I started seeking out people that knew what this was all about. And I joined Save the Patriots. I met Eddie Kane. I met quite a few others, and we shared information through the mail and telephone conversations. And I started going to the law library, where my office was right next to a college, and it was nothing just to go down the street and go to the law library and start looking up all these statutes, rules, and regulations. So then, after that, about 1991 or so, I wrote a few letters to the IRS asking them about what I found and could they please advise. And basically I got negative responses. My CPA, I said, pursuant to section 1441, 42, 43, I don't see where I have any aliens working for me. I don't have any organizations working for me. So why am I a withholding agent on people that the code doesn't apply to? And he literally wrote me a letter back saying I need to find a new CPA. So I started, you know, that really kind of ticked me off, because all I wanted was an answer. You know, I mean, I wanted to understand. I truly wanted to understand what was going down. So then I would go back to the IRS office, where eventually they said, Mr. Chapman, you've been here so many times, we're not going to answer your questions. We don't have, you know, we don't have the answers for you. And I said, well, wait a minute. If I wanted to know about a driver's license, I could walk into a police station and get the proper answer. And you're telling me that you can't answer what tax I'm liable for and subject to? You can't tell me that there's a law, a statute, rules, or regulation that it compels me to sign a 1040? And he said, we're not going to answer those questions. I said, oh, okay. So then I left, and now I'm gaining more knowledge and so forth, and I'm not sure what knowledge I'm gaining, but I knew that they're hiding something. So then in 1993, I stopped filing. I said, I'm not going to file anymore. Nobody's going to tell me what law, I'm not going to file. So I was a member of the Save the Patriots. I thought they had a real good program. The program was that you pay $650 membership, one-time fee, and I think it was so much a year, but and so much a letter. So if you get a letter from the IRS, they'll respond, and of course they'll copy everything to me, which I thought was good. It gave them the power of attorney to do such. Well, I started getting letters about 94, and so I would send them up to Save the Patriot. They would send the letters back, and instantly, I always take these letters and I go to the law library and I start looking up what they're answering with, because it was important to me for two reasons. One, I wanted to learn what they were doing, what they were saying, and two, to make sure that they weren't putting the handcuffs on me, because I didn't need anybody's help to go to jail. I've done that, been there, and I don't need help doing that. So I thought everything was on point. Then I met Eddie King, and Eddie and I got along pretty good, and so about 95, the friend of mine that originally was telling me he's an alien to that nation, that I told him that I'd be getting him out of jail, well, he came up from Fort Lauderdale and started working for me. He was working for me as a salesman. And when he was getting hammered by the IRS, and we planned, and we figured, okay, look, when I get books and summons, you answer for me. When you do it, I'll answer for you, because how many people have gone through a process of books and records? You know, and it's kind of inundating and nervous for you to do it. But when somebody that is knowledgeable, or at least, you know, is like-minded, he's not under the stress, so he can sit there more comfortably and think more clearly. So when he was down to the IRS, they would ask him questions, and of course we never answered the question without a question. And in the process, I'd be glad to provide whatever you wanted to provide. Can you show me the law, the regulation that compels me to do so? And they would always say, we're not going to have this argument. And so, well, where do you see the argument? Did I refuse? I'm offering to do it, but I need to know if you have the authority to do so, because it seems to be a pretty big secret. You won't tell me. You just want me to do something that you are not showing that you have the authority. So this went back and forth and so on. So then he started standing on this Fifth Amendment right. Now, a lot of people didn't know at the time, I think we're more educated now, that when the IRS says, are you going to stand on your fifth on every question we ask you, a lot of people said, yeah. Well, that's not the answer. The answer says, I don't know. You haven't answered all the questions yet. So then they brought him, they wanted to bring him to court. So he did an abatement. He sent the abatement in. Well, he never got a response. And now he's up in Palm Bay with me, and the court thing is down in Miami. So he says, I said, well, Rod, you better go to court to see if they call your name there. He said, no, they didn't respond. He says, so, you know, so I win by default. And I said, well, you didn't put a default in, and you better go down there to see if they call your name. Well, he didn't. And so he went down to Fort Lauderdale for the weekend with his wife and kids, and 2 marshals picked him up. So he sat there for 6 weeks in jail. And like I said, I'd be sending him money for cigarettes and everything. And we couldn't figure out what's going on, because, you know, he told that he didn't really get in front of the judge. He was just in jail in contempt. So we sent his wife down into the court records to look into records to see what we can find. Long and behold, now the IRS has been writing to this man for 6 years. Proper address, proper name, proper city, zip code, the whole 9 yards. All of a sudden, they sent it to the wrong city, same address, but a different city. So it was returned. And the envelope was unopened, and it was just said return to sender. So we had her instantly bring that to the judge's attention. And before the sun went down, he was out of jail. And so, and since then, he's never heard any more from the IRS. And that was back in '95. Then the IRS was coming in my office. They did another audit through the company, and the company I didn't mess with. I mean, they paid all his taxes and so forth. And they used that as to look into all my records, and they see how much money I was making. They said, well, you're not making any returns, are you? And I said, am I required to? And they said, well, you know, we're going to come in and do this and do that and so forth. And I literally threw them out of my office. There was 3 agents coming in there, and I had some gutsy guys with me that worked for me, and we all stood in front of them and said, we want you to leave, and we want you to leave right now. And so they left. Then in '96, I sold my company and started working for other pool companies. Well, then and it went back and forth, a lot of letter writing, and I've never refused to pay. In fact, I always started there. You know, the Eddie King way was a way that I truly agree with, and I still do it today. I'll offer to do anything you want me to do as long as there is a requirement for me to do so. I'm not refusing. And I always thought that was a good way. It's a non-combative. You're not saying I'm not responsible. I'm not. If I am, I'll pay it. It's as simple as that. Well, in 2003, I had a CID agent come knocking on my door, and he says, he introduced himself, and I said, I'll be right back. I'll meet you downstairs. And he said, can we come in? And I said, I don't think so. I'll meet you downstairs. Well, here they are. They're dressed in black, and I live in a condo that it's a big windbreaker off the river. And it was on a September day, and it was warm that day, and we're standing out in the parking lot, and I brought my tape recorder, and I started asking him questions. He said, well, you can't take this. I said, well, we can't have a conversation then. And he said, well, I got to get my tape recorder. I said, okay. And so he said, well, I ain't got it. I don't have it with me right now. I said, okay. And he said, well, can I come back in a half hour? And I said, okay. So he came back in a half hour. He just needed batteries, is what he needed. So we started taping each other's conversation. And the first question I asked him is, do you have your delegation of authority, by the way, from the secretary? And he says, what? And I said, do you have a delegation of authority that the secretary had authorized you to come and talk to me? And he said, no, I don't have that. And I said, can you get that for me? He said, well, I have to look into that. I said, okay. So I started turning around, walking away. He said, well, I got a few questions. I said, what are your questions? And he said, what is your name? And I said, you already got that. And we went back and forth, and basically he left with the understanding that I wanted to know that he had the authority, the jurisdiction, which he claimed he had the jurisdiction. If I was born in New York and I was raised in New York and I live in Florida, he has jurisdiction. And at the time, I didn't know what I know was up on the screen, but I said, well, you know, I read the code differently, and I don't see where you have jurisdiction, but I do need a copy of your delegation of authority. Well, henceforth, I never got it. Then he came back, and in that conversation, we were talking about can I know what tax I'm liable for, subject to and liable for, that is due and owing the United States Treasury? Nobody's ever told me the tax. And he said, well, I browsed your folder and I've seen that you've gotten that information. I said, well, obviously, Mr. Solar, you've seen documents that I haven't seen. May I get a copy of them? He said, well, I don't see a problem with that. He said, I'm going to be out of town for a couple of weeks, but when I get back, I'll get them to you. I said, great. So he comes and he leaves a bunch of letters that I've gotten over the years. You know, just bills, you know, hey, you owe this amount, and, you know, and we're going to make your life miserable if you don't pay, and all that. And so I went to the store, copy store, I copied all of them, so I have it for my records, and that's an important thing, is keep records. A friend of mine, and I don't know if I have it with me or not, I don't think I do, but we put it on a spreadsheet, you know, date, who came, what happened, and so forth, and it's a long spreadsheet of events, you know, and it's very helpful. I can't tell you how helpful that is. You got to keep good records. And so I made copies of everything as staples, and then I hand delivered it with the witness back to the CID agent in Maitland, and which he wasn't there at the time, but I put it accepted for value and returned. And so he calls me up a few days later, and he says, he starts asking some questions. I said, did you get my package? He goes, yes, I did. And I said, you said that you had documents that claimed, that showed the tax that I'm made subject to and liable for, and I didn't see it in there. And he says, Mr. Chapman, I'm not going to go through that with you anymore. I said, what's the big secret? And he says, you owe a tax, you're under criminal investigation, and we're going to move forward. And I said, okay. I said, I guess I'll be seeing you. So, moving along, I can't think of anything really relevant, but moving along to recently, and I'll get it on the thing here. Let's see. Recently, he comes in with the handwriting, voice, fingerprint, and photograph exemplars. He comes knocking on my door around 7-ish or so, and he says, Mr. Chapman, and I said, yes, and I didn't recognize him. You know, it's been a while since I saw him. He said, David Solar, and I said, well, I'll be darned, how you doing? And he said, good. And I said, how can I help you? And he said, well, here's a subpoena for you to come before a grand jury. I said, great. I said, I'm going to be in front of a grand jury? And he goes, yes. I said, oh, man, great. And he looked back and he said, well, you know, if you don't want to come to the grand jury, you know, you can come to my office and do the exemplars. I said, you kidding? This is an opportunity. No, I want to come to the grand jury. And he said, okay. And so he told me the date and everything. And there was one before this, that all that conversation really happened. They added the voice, fingerprint, and it was originally the handwriting. So when I get to the grand jury, I give them a complaint that, wait a minute. Grand jury handwriting. Now this is where some of this stuff that I'm showing you is going to give you the confidence that if you and you can put it to your own advantage in your own personality and everything. But what I learned is you don't want to be a defendant. You don't want them chasing you. You know, it's just like in the back in the early school days. You know, you always had a bully in school. You know, and you see him walking down the hall, and you go in the classroom that is in session, and you don't belong there, and you're making excuses. You can't find your classroom until the bully passes, you know, and then you go down the hall. and instead of just picking up a bat and telling the bully who you are, you know, and to leave you alone. And this is what this complaint is all about. This complaint is going to make you very confident, especially if they're trying to criminally indict you for willful failure to file. We know there's 3 elements of willful, you know, and one of them is you gotta know there's a legal duty. And the second, I think, is, and you fail to do that legal duty. Am I right, Marlon? Isn't that pretty much it? Yeah. And so when you make known to Congress that 80 members of Congress, including and not limited to the Judiciary Committee and the Committee of Government Reform and Joint Committee of Taxation, as well as the Ron Paul, how is the U.S. Attorney going to tell a group of people that are basically puppets on a string, and you know that you're willful when you go in there? Now, a lot of people, when they get a grand jury, not an indictment, but a grand, you know, being known that the grand jury is going to be investigating them, the first thing that most people do is they get in a closet and start praying. And that's not bad. But the thing to do is, once you get out of the closet, knock on the door and say, hey, I want to see that grand jury. And you're not going to talk about the grand jury, about definition of a person, or the legal determination, the definitions of 7701 and all that, because basically you're going to go through what the prosecutor has already prepped the grand jury, that this is what you're going to come, this guy's going to come in and tell you he's not a citizen of the United States. He's going to tell you he's not a person. He's going to, you know, and he's going to make it sound like you're so stupid that when the grand jury hears it, they're just going to be yawning and just waiting for you to get out so they can indict you. But this handout here is basically a what do you call it? An overview of what's all in this complaint. This complaint was written by David R. Merlin out of Oregon or Washington, and he sent it to Albert Gonzalez, Snow, who was the Treasury at the time, Everson, and others. And it was produced by some people out, like one guy out in Texas that had to go to court, and they were using the law in their defense, and the DOJ had a block on him using the law. And I forget the term, the legal term for that, but they didn't want him to use it. And the judge made it so. You can use the law in this. So that's what I think helped spark the complaint. But when I went in front of the grand jury, I said, after I got sworn in and everything, I sat in front of the grand jury and I kind of just like looked at them. And I said, well, I really appreciate you all being here. I know you all think that, you know, you're here to investigate me doing the crime. But I'd like to tell you something. I said, I got a 200-page complaint here that I filed with Congress, over 80 members of Congress, about the crimes that are being committed by the one agent, C. Solar, in the other room there, because he wasn't allowed to come in. And I'm going to be naming that U.S. Attorney. What's your name? Henselwood? Yes. Mr. Henselwood. And in the joiner. And so, because the crimes that are being committed, that man cannot show you, under Title IV, Section 72, where Congress extended the authority to the Secretary to come into the 50 states. It's not about this IRS code here, what the Secretary can do. There's no questions about what the Secretary can do when you read this book. This book has thousands of pages talking about books and records, summoning, taxes, excise taxes, and so on. But nowhere does this book have the authority within the 50 states, unless that attorney sitting over there can stand up right now and tell you where Congress extended that authority. And to give you that, and so that you all understand, right down here, it says under Title 48, USC 1421, the income tax laws enforced in the United States of America and those which may hereafter be enacted shall be likewise enforced in Guam. Then you go down to 1801, approved and covenant established in the Commonwealth of the Northern Mariana Islands, and so forth. So Congress extended the authority in Guam, and we can show it in Puerto Rico, we can show it in the islands. So they didn't run out of ink when they did not mention Florida or any of the other 50 states. How many of you think they ran out of ink? And not one of the jurors raised their hand. I said, so when you have a section of the code, and by the way, the section of the code that I'm naming under USC 472 is positive law, and that's about all I said about about positive and non-positive law. But all offices attached to the seat of the government shall be exercised in the District of Columbia and not elsewhere. Okay? Except otherwise expressly provided by law. Now, the U.S. Attorney is going to get up and tell you, after I leave, of course, he ain't going to tell you now, because he's going to get up and say, you see what I got to go through with these guys, man? They just won't listen to the law. But he's going to tell you that law, he's going to give you the Hughes case, which we've been in front of already 3 different courts. We've talked to over 44 attorneys, and not one of them have come up with the answer to the question of 472. And the Hughes case is where the grand jury should not be deceived by the smoke and mirror tactics of the U.S. Attorney. For example, non-responsive answers by the U.S. Attorney are that they are. The U.S. often cites Hughes versus United States. And I'm going to show you where the judge used this against me after she's already had this. So they just, this is all they can rely on. The Hughes ruling claims that 472 does not foreclose the authority of the IRS outside the District of Columbia. The only reason given by the Hughes case is that the President is authorized in Title 26, 7621 to establish internal revenue districts outside of Washington, D.C. The rebuttal of this argument is as follows. It should be clear to this grand jury that the Hughes court to state that the President is authorized to establish internal revenue districts outside of Washington, D.C. and is not the same as saying that the President can establish the district within the several 50 states, especially in light of 472. I have shown you that Congress has authorized the Secretary for the areas of the Virgin Islands, Guam, and the Northern Marianas. And it goes on. And you'll have this document, and I would beg you to read it, understand it. For me, it took a while. I mean, I'm on the conference calls every Wednesday night, and I'm on Joe Saladino, who is the overseer for the Freedom and Privacy Committee, is the one really hammering on this. And in there, you'll see some mandamuses, you'll see some court things that I've done regarding this argument and so forth. The courts can't argue it. They cannot come back. There was a guy in that, I think Missouri or Arizona, that was using this argument. And there was something like a 30-page argument all on Title IV, Section 72, and the Hughes case, and you know, they just bring it all up front. And a 2-page from the DOJ. Meritless. That's all they said. That's all. That was their rebuttal to Title IV, Section 72. Meritless, you know, let's just get them. And because of the family, his wife and other people, and the court was suspended. They weren't moving anymore. You know, they were just coming on like crazy. Then all of a sudden, they're not moving. And I guess the not knowing what's going to happen, you know, the silence was getting the family, and the family hammered them into making the deal with the IRS. And we threw our hands up, you know, said, man, you have it. You have it, because if they have failed, now you can go right to the Supreme Court with a question. You know, so, and that, so but that's his life. So with that, the grand jury got all this information, and I went through this document here.
Did you remove that side column?
And I'm challenging the U.S. Attorney and the Secretary's statutory authority to operate within the 50 states. And as I was reading this to the grand jury, I was looking at the DOJ as I'm looking at Bob. I said, I'd like to have him answer right now, where is your jurisdiction? Where is the Secretary's authority for me to even be in this chair? I came here specially, and not generally, just to find this out in front of the grand jury. Because under Title 18, Section 4, it is my duty to report a crime, and you, sir, have committed a crime. And I like to know the answer to those questions. And I said, now, does anybody here have any questions? One juror sitting there like this in his chair way back. And I said, yes, sir. And he said, what questions would you have us ask them? I kind of looked down thinking, boy, this guy's lights ain't on. I mean, I just sat there for a whole hour talking about the questions I've been asking the IRS, talking about Title IV, Section 72, about the Hughes case, and all I want to know is just the several questions. And I went through the questions, and here he's asking me, what questions? So I lay quiet for a minute thinking, I don't want to be redundant. How about if I mailed you back a list of questions that you can go one by one and have them answer? Would that be good? And 4 or 5 hands popped up. Yeah, that'd be great. He gets up and he says, you send those questions to me or David Sullivan. And I said, why would I send them to my adversary? They're about complaints against you. And he said, I said, what assurance would I have if the grand jury would get them? If it's appropriate, they'll get them. So I didn't answer. I just said, you know, I just you know, acknowledged I heard it. Then, at the end, let me just see. I'll find it in a minute. Then at the end, the U.S. Attorney says, well, he asked me a couple questions. Now I want to go back. You know, I did the Pete Hendrickson thing. You know, I never filed from '93 to 2005. Then I read Pete Hendrickson's book, and so I said, wow, this sounds great, because Whenever I had a thing with the IRS, I would ask them, you know, what code or rules or regulations am I compelled to perform? Can you show me the law? Mr. Chapman, we're not going to have this argument. I walk out of there. Where's the argument? You know, I didn't refuse. I'm not offering. Well, it makes sense what Pete Hendrickson was saying is that, you know, employer sends information under the penalties of perjury to the IRS that you made money either as an employee or as a trade or business, and you didn't rebut it. You didn't correct the application or anything like this. Well, and and at the time I thought this is it. This is the answer. I didn't expect any money back because I didn't pay anything in. But then I got my daughters, they did it, got money back, and people that I helped do it, they got their money back, and so forth. Well, now they're coming back after my daughters. And I'm thinking, well, you know, what's the problem? They corrected the forms, you know, and they set the administrative record properly, you know, without, under the penalties of perjury and the whole 9 yards. And so with that being said, the U.S. Attorney says, did you make returns and put zeros on the 1099? And I said, well, in answering to your question, are you asking me that I correct the 1099s that it was originally sent in by the people to who I was working with and for? And he said, did you put zeros on the 1099s? And I said, I calculated the income that I made. And I put zero where the calculation came out to zero, if that's what you mean. You know, because, you know, putting zeros like Irwin Ship, zeros, zeros, is not adequate. You know, you have to do a calculation, and if you didn't make any gross income, and then you can't have adjusted gross income, so it only comes out to zero. But and that's all the question he asked. He just asked in front of the grand jury. That's all I did. Basically, I said, you know, I corrected the 1099s because pursuant to the 1099s is for trade or business only. And trade or business as defined in the Internal Revenue Code does not apply to me, or does it? And he didn't answer. And so he, and that's all the question. Then he said, now, Mr. Chapman, pursuant to our conversation prior to you coming in to the grand jury, which was unique in itself, at the time, before going into the grand jury, he didn't know what I was up to. And he was like a guy you would want your kids to have as a grandfather. I mean, this guy was great, you know. Hey, you know, we got a great judicial system here, and because we have a great judicial system here is why you can go in and give your testimony. But you know it can be used against you in a court of law, don't you? And I said, yeah. I said, I know it can be used against you. And he says, so, you know, but it may help you and so forth. And we got a great system, like I said. And how much time do you need? Do you need 10 minutes, 15 minutes? I said, I don't know. I've never been in front of a grand jury before. I don't even know what to expect. Oh, they're just a bunch of people like you and I just work, you know, and they're doing their legal duty and so forth. And he said, how much time do you think you need? I said, well, why don't we say an hour? And if I go over, is that a problem? He said, no problem. And he said, now, do you have any other questions? I said, no, it seems like the government is here to help me. And he knew then that, you know, something's wrong. Well, by the time, at the end of the thing, he couldn't wait to get me out of there. He was, you know, like, okay, do you have anything more to say? I said, well, yes, I do. And then I went into another Title 80, Section 83, which we'll get to that in a minute. But so after that, he said, okay, now pursuant to our conversation prior, you understand that you're going to provide the exemplars. And I said, well, yeah, I understood your question and everything. I said, but now there is a challenge on the table pursuant to my question here that you didn't answer in front of the grand jury yet. Where is the authority from the Secretary that authorizes by Congress for them to operate in 50 states? Can you tell me that? So you're refusing to do the exemplars? No, I'm not refusing. I'm wanting to do it, but I'm challenging y'all's jurisdiction, which they got, well, that's another story, the federal district. But, and he said, okay, you're refusing. I said, no, I'm not refusing. He said, well, go wait in the other room. And so I got up and I thanked, all the grand jurors and everything for their time and everything, and I will be sending you the questions. So I went into the other room, and David Solar and this other guy was sitting there. This other guy was kind of a trip. He was another agent. I don't know if he's learning or what, but all he did was just look at me. And I'm talking to David, and all he's doing is just staring at me. Just sitting there, nothing, no grin, no nothing, just staring at me. So I said, can I have your card? And he got me, and he gave me his card and everything. And I said, he is a witness. And he still didn't say anything. So David Solar's telling me, he says, okay, now Mr. Chapman, and he's slipping his paper in front of me. He says, now, you're gonna, it's gonna take you about an hour and a half. And he said, we don't want your hands to be cramped and everything. And I said, that's really thoughtful of you, Dave. And I'm looking at it and everything, and I said, he said, so you get ready to get started? I said, yeah, I am. I said, I'm waiting for an answer. The U.S. attorney hasn't come out with it yet. He said, oh, what's the question? I said, I'm waiting for the answer where the Secretary was given the authority by Congress to operate in 50 states. Do you know it yet? And he just sat back like a wet noodle. And I said, Dave, can you tell me where the law is? What tax am I owed? I said, that I owe. I said, is it a secret? He says, I can't tell you. So then the U.S. attorney comes in, and he was livid. I mean, he was mad. Now he looks like a bulldog, and he's barking at me and everything. And he says, well, go home. And I said, and he says, and you're going to come back here on the 24th, and you're going to do those exemplars. And I said, okay. I said, is it all right I go home now? He said, no, you can't go home. No. I said, no, you're not released. And I said, well, you just told me to go home. He said, well, of course, you can go home. I said, okay, thanks. So I go home. So then I come back on the 24th. Now, in the meantime, let me see if I can find the questions here. Let's see. The question to the grand jury was,
grand jury handout.
huh?
That back one had a grand jury handout.
No, the grand jury handout was what I gave the grand jury at the time, and then I gave them, I sent them a bunch of questions, and I sent them the way I sent them by, I can't hear you.
There's a question and answer box you have up there.
Oh, yeah? To the right? Oh. Let me see. I sent them by registered mail. In fact, I got them right here. I sent them by registered mail. Then I sent them by questions and answers. I sent them by registered mail, I sent them by carrier, I sent them regular mail, and I sent a copy to the DOJ here in Orlando as well as Washington. And and to my knowledge, I'd be willing to bet that the grand jury did not get to see them. Which is going to be interesting if they try. Let's see, let's take this back. I think this might be it. Yeah, this is it here. On the 24th, I made a special visitation. No, it wasn't on this end. I'll find it in a little bit. I'll go on so we don't get too bored here. The interesting thing is the subpoena. This is quite interesting. The subpoena is written on a form. And while I was going up on the 24th, which I thought I'd be up there for at least a little bit, because I thought I was going to go in front of the grand jury again regarding the questions. And I had three gentlemen with me that went to the clerk of the court. And they went to the clerk of the court because on the bottom of the subpoena, on the left-hand corner, it says, on application of the United States of America. And that kind of bugged me because on application of the United States of America, which of the 50 states is acting on behalf of the other states, or who is acting on behalf of the 50 states? Because to me, the United States of America is the collective, the several states. And so I asked them if they would get a copy of the application for me. Well, as I understand, they went there and asked the clerk, not the clerk, the clerk, a clerk, where is the application of the United States of America? And she looks at the form and says, oh, that's not our form. That the DOJ has that over there in our office, and they just stamp it and send it out. And one gentleman said, well, let me make sure I understand. This is the clerk of the court's document, isn't it? A judicial document. And it's over there in the DOJ's office, and they stamp it? Are they using the clerk's stamp and just sending out notices? She said, well, we haven't used this form for 10 years. So basically what they're saying is that the DOJ, the executive branch of government, is using the judiciary stamp and stamping the subpoena and mailing them out like mailers. Well, let's get this guy and let's get this guy and so forth. And so they're usurping the powers of the judiciary for their advantage. So I wrote a letter back to the DOJ, to the clerk, asking her about that. And she writes me a letter back stating that pursuant to Criminal Rules 17, that the DOJ can, get we stamp it, they fill in the addresses and everything and send it out. But that's not what happened, see. The clerk testified, not under oath, but I mean, she admitted that we don't have this form here, that's not our form. So that's another question is coming up, if at the proper time. So when I went up there on the 24th to go up there, there was 4 agents sitting there, like they were just coming out of, a funeral. They're all sitting there real quiet and solemn, and I walk in there cheerful. I said, "Good morning, people." I said, "How are you today?" And the attorney looks up and he said, "You ready to do the exemplar?" I said, "Sure am." Do you have the question, the answer to my question? "Go home," he says. I said, "Go home? I want to see the grand jury." He said, "Go home. I'm asking you to go home." I said, "I'm asking to see the grand jury. And now are you going to be complicit? Are you going to commit another crime and prevent me from testifying before the grand jury?" He said, "Go home." I said, "Okay, have a great day, guy." So then I turned around and walked out, and he said something, and I guess that he was going, oh here, wait a minute. He was going to, here, question. This is the questions that I gave to the grand jury. This is in your document. Okay. So then I get an order from the judge that now the first hearing was on January 10th. This order said on January 11th, there was a court order for me to compel to perform. Well, I never got that court order. There was no order, to my knowledge, from January 11th. So again, this is something the courts are using to do something that wasn't true. Now here's the questions that I was asking. And I got them numbered, and again, I'm going to run through them. I don't want to go down each detail. You all have a copy of it. And I think that if a lot of these questions will help people to understand Title IV, Section 72, and how important it is. And it goes through again where Congress had the intelligence and the knowledge to write where the Secretary does have the authority, and they didn't write where he doesn't have the authority. And so, our laws are written on what you can do, I guess, and not what you can't do. So, the question is here, how can Chapman be charged for willful failure to file if any officer unsubstantiated charge which Chapman has repeatedly asked numerous of IRS agents and the Secretary? I didn't include it in this, but I got an affidavit that's almost as thick as this complaint, with numerous of statements and followed by questions. Just rebut it, if you will, just one, and they won't do it. And I end here with a big, in the original copy, I think it's in big blue letters. Here it is, big blue letters. It is my firm promise to the grand jury and to the United States, if Solar or Henselwood, which I nicknamed the Blockhead, his head's bigger than mine, can produce just one law which Congress has expressly extended the authority of the Secretary to the geographical area of the several states, which is outside the District of Columbia and not elsewhere pursuant to 472, I will promptly, within 30 days, make arrangements with the IRS to pay all taxes allegedly owed by me for all the tax years in question. And I will notify all my friends. You will be all notified. I will have another meeting. And associates of said law, and recommend them that they immediately pay their taxes and file their 1040 return. So if they tell me the next meeting will be that I'll be recommending you to do that. But I can assure you there won't be another meeting. However, if someone cannot produce said law, then I respectfully request the grand jury immediately begin an indictment proceeding against Sullivan and Woods for the crimes they have committed against me, as cited in here and verified herein. Why is it verified? Because they haven't responded. They haven't rebutted. They have said nothing. By their own admissions, by being silent, they agreed. They can't come at me anymore, you would think. So I get this order from the judge. Judge tells me I got to come in and show her why I should not be held in contempt and not put in jail for, I think, up to 18 months or unless the grand jury, disperses before then. Why should not be held in contempt for failure to perform the exemplars? So I spent all night, the night before, it's like everything else, you want to do your paperwork and you want to get through court proceedings and the people are helping you. And let me tell you something, I couldn't do this alone. I thank God, my commander-in-chief, and that he has given me the people in each step of the way. It's not like, I got all this in front of me and God has already opened the road. It's just like when I'm ready to step into a hole, somehow there's a bridge there that keeps me afloat. And I can't tell you, man, how much I appreciate them. And I'll name them later. And then I sent this affidavit of sham legal proceedings, which is a gentleman here that helped me put this together, and is one of my favorite documents because, if somebody's claiming that you owe them money and they put it on the record and certify it, does it become a security? Okay? If evidence of a debt is a security. And now the question is it a false security? Or do you really owe the debt? If you don't owe the debt, then it's a counterfeit, isn't it? And and that's where the Security Commission can get involved. There's other agencies that don't like other agencies, and I don't know anybody likes the IRS. Okay. Here now. This is in addition what I sent in after I sent the grand jury the questions. I also sent a copy of this to the grand jury because I wanted them to know that by affidavit of sham legal proceedings. Now the sham legal proceedings came from Rick Schramm. Rick Schramm used to be one of the founding members of Right-Way Law, and very, very interesting guy to talk to. I sent on eSNPs a conversation that I had with Rick regarding this thing, and it seems to be a powerful title. Promoting counterfeit securities and other violations of federal law. Now, Randall Gold is the initial U.S. attorney that started action against me. Blockhead, Henselwood, I know I shouldn't be saying that. I should always be respectful, even to Diana. It's hard to do. Okay, Perez is the head of the U.S. attorney in Florida, or at least the Central District. Patricia C. Fawcett. Now, she's the chief judge that evidently has a lot of the...
You're gonna make it difficult for me now, huh?
She's the chief judge that handles a lot of the tax cases. And interesting enough, at the hearing, which I haven't gotten to yet, but I don't know if it was boasting, I don't know if it was a warning or just threats, but Scott Slayback isn't here, is he? But she said, you know, Scott Slayback is a very intelligent person, and you shouldn't follow the road that he took. And Rick McLean, I don't know, some of you don't know Rick, but Rick's a real good friend of mine, and she has literally destroyed his family, even sent his wife to jail for 2 years. And so I don't know if it was kind of like a bragging or what, but they said, you know, the road you're taking, Mr. Chapman, is a road of doom. And I said, Your Honor, I said, my God's bigger than your God. I don't know what to tell you. And so Aline O'Connor is the Assistant Attorney General up in Washington. Robin Chambers, I call, she's an agent, I call her a lot of names. David Solar is the criminal investigator. Scott Ellis is the clerk of the court. Now what's his role in this? He has a notice of federal tax lien on the record, and he has utterly refused to even discuss it. He said, that's your problem. And I said, well, it's soon to be yours. Joyce Stieber, who is the manager of records, who is now retired, but soon I'll be going after her bond, which we'll discuss at a later date. David T. Russell, who is named in my complaint, but being so embarrassed, he wouldn't give me his bar number. T. Davis Wilson is an attorney that was a witness standing at the grand jury. She was at the grand jury, and they asked if I'd mind. I said, no, more witnesses, the better. James Worth is the agent that is, I guess his job is to stare you down. Kelly Lewis is another CID agent who works with David Solar, who's been at my place. And Ron Sears is a new agent that I met upon Solar delivering the subpoena. So, and a lot of you know Margie and Jack out of New Mexico, I assume, because I've seen a lot of faces over there. We used her presumption letter. Okay, this letter is a lawful notification to you pursuant to the Bill of Rights of the National Constitution, particularly to the First, Fourth, Fifth, Sixth, Ninth Amendment, and the Declaration of Rights of the Florida Constitution, and I name them. And it requires a specific response on the subject matter that I'm bringing here. And it is your legal, lawful, and binding agreement with an admission to the fact that everything in this letter is true, correct, and lawful, binding upon you in any court anywhere in America without your protest or objection, and that those who represent you, your silence is your acquiescence. NC Conley versus General Construction. And notification of legal responsibility is the first essential due process of law. And isn't that what I've been asking for all along, your delegation of authority? And in your silence, of course, the famous case will be equated with fraud. Now, and it goes down to, I'm not going to go down to all the questions again. You have them. I would insist that you read them, use them for your own personality, for your own problems and your own techniques, and come out. This is something that was well thought about, well thought of, and worked with a lot of going back and forth and making sure that everything was in its proper place. Now with Perez and Blockhead and the other guy, Gold, it says it took a sworn oath to uphold and protect and defend the Constitution of the United States of America as a U.S. attorney, and he willfully misrepresented the U.S. of America without the power of attorney. I mean, it would seem like if the 50 states are involved, somebody had to give them a power of attorney. And being that you are all within the 50 states, did any of you give the power of attorney? No? Anybody here? Okay. So nobody has done so, and it goes on. The agent, and it goes to the clerk of the court, and it goes on down. And then a lot of the stuff that I've taken out of the affidavit that the secretary and Everson had previously gotten that didn't respond to, and gives all kinds of the TDOs 150-42 and 150-0102, which is decommissioning the regional service centers and their directors, which hasn't been reestablished. And it goes down, and then it goes down into by their tacit agreement, they agreed to all the statements of fact, and therefore, let's see, the law cites very specifically, which makes Christopher Chapman liable for the income tax of federally regulated activity, which Christopher Rose Chapman engaged and made him liable for said tax. And it just goes on and restates everything that I've been doing since 1993, or even before. 93 again is when I quit filing. But I started asking the questions before then. And nothing has really changed. It's just more information to back me up on what federally regulated activity or event that I've been subject to and liable for makes me do and owing the United States Treasury. That's all I want to know. What have I been involved in? And and now with Title 4, Section 72, I've been made apprised of that within the last year. And that is, has been a big, that to me is the putting the lid on the jar. They can't move now because I got them locked in. And to go back, and I want to make sure, okay, affidavit of shame, okay, I'm pretty sure about that. Let's see, do we see affidavit of shame here? Before I go, let's make sure I get it, because I want you guys to have it, because that's a real good document. Okay, yeah, here it is right there. So you do have it. Now, during the break, somebody asked me, do I support Pete Hendrickson? And one of the things that's happening in the community, in the patriot community, if you will, is everybody wants to be right and nobody wants to be wrong. Nobody wants to be corrected, and everybody is the guru. And that's a sad position to be in, because I don't know anybody in the world that knows everything. And I don't know anybody in the world that doesn't want, well, I take that back, there are some people that don't want to learn. But I don't know, like Pete Hendrickson wrote a good book, and it made a lot of sense. And the sense was that all the definitions that the IRS are using against you. And it makes a lot of sense. There's no doubt about it. But something has come up recently that Pete Hendrickson won't acquiesce as a possibility. And when you have so many people that know a lot of things, there are some really talented people out there. There's talented researchers. I mean, I read some of this stuff, and I got to read it 50 times. I got to call my friend and ask him, let's talk about this, because there's some things that I don't understand. And he may say it in such a way that I do understand, or I may have to talk to somebody else and get their understanding. And through 3 or 4 different people, now I understand. It's not that I'm thick-headed, it's just that I don't have a high school education, so there's and I'm not afraid to say well, what does that word mean? And of course that's what they made dictionaries for, to find out what the word means. But of course in law, you got to look up in the law what that word means, because a whale could mean a cockatoo. It doesn't really matter, It's what matters is how they're using it against you. So when I joined this complaint back in April of 2006, I joined it because of Walden out in Texas, a nice guy, and he'd been hammered hard by the IRS. And he told me about this before, when he was getting involved in it. And I said, well, I'm being inundated like a bunch of us, with too much information, and it takes me time to cipher out. Because generally speaking, unless I know it came from an absolutely good source, I will look up every single word that somebody gives me. If somebody says something like for instance, Linda Wall came out with this counterfeit securities. Great argument, and it worked good. But I went and looked up everything so forth. And just like Pete Hendrickson, even though that I knew his book, I knew what he was talking about, now he put it in such a perspective on how to use it. Who else can make out a return and get your money back? And if you go to his website, I think now it's over $1.5 million has been returned back to the people. What he doesn't mention is all the people who's getting hammered after it. And one of the things that's really interesting that would make Pete Hendrickson's system awesome and ironclad if he would only acquiesce to the possibilities of Section 83. And Section 83, and this would work really well if you're required to come into books or records. And we'll talk about being summoned for books and records later. But Section 83 is one heck of a brief. And I'm going to sit back here and read what's on the website here, but where is that? On the screen. But as you know, the Title 61A defines gross income, and gross income is defined except as otherwise provided in this subtitle. Now, that means there's going to be an exclusion someplace, because why would they put it there? You know, how often do you ever see except otherwise provided? So that's a clue when they put something like that there. And like I said, I'm not going to go down and read everything, but if you go down to number 7, it says, however, citizens with tax professionals rarely read and understand the 7 words of 61A, except as otherwise provided in the subtitle. This subtitle clue to let citizens and tax professionals know that there are other definitions or exclusions from gross income, which supersedes title this 26 USC 61A, definition of gross income. For example, full-time ministers can exclude the rental value of their home and furnishes, and as as from the gross income, and in business, when you have a business, you take something you buy, and you sell it for a profit. Well, you pay the tax on the profit. You don't pay the tax on the money that was made outside of the profit. And what Title 83 does, which Dave Merlin did an excellent job on this. Go to number 10. For the past several years, millions of citizens have received compensation for services actually rendered and considered to be included in gross income. The summary, 26 USC 83, explains how property received in exchange for services rendered is taxed. USC 83 explains how property received in exchange for services rendered is taxed. Did I read that twice here? Section 83 applies to all compensations paid for both the services of corporations and for services of individuals. Labor is property, and your labor is your property. When you give your labor in exchange for Federal Reserve notes, or silver, if that ever happened, you're exchanging property for property. Anything excess over, above that, would be gross income. Understand? So, it has been well said that property, which every man has, which every man has is his own labor, as it is the original foundation of all property, so that it is the most sacred and inviolable. The patrimony of the poor man lies in the strength and dexterity of his own hands, and to hinder his employing his strength and dexterity in what manner he thinks proper, without injury to his neighbor, is a plain violation of the most sacred property. I'm reading words that are not there. And that's in a well-known case. Now, if you go on, and I'm still studying this out, so I would like to know this like I know the other things, but again, it takes time to really get this into your mind, because you got to read it over and over and keep speaking it and understanding it. And but the DOJ on this will go on to show you the DOJ on 4 different occasions, when they were after somebody's property, they got their money. One of the cases that the defendant argued, well, I need money to pay my lawyer. What part of any property you don't understand? The DOJ won. They took all of the money. Why? Because it was his property. So when you exchange your labor for money, that's your property. and it can't be taxed. In fact, in Title 15, under the Commerce, it explicitly says that. So and the DOJ has successfully 4 times won, and it goes down to, here, let me get to the DOJ part. And this is provided, and by the way, you can find a lot of this stuff on freedomandprivacycommittee.com. And the link will be on the disc, and which is to my website there. And you go under new briefs, and you can download a lot of the stuff that I've already given you on this regarding the mandamus, Title 42, Title 4, Section 72, and this 83 brief. And
What's that website again?
it's freedomandprivacycommittee.com.
Committee.
It's, in fact, it's freedomandprivacycommittee.com/9326. That way, if you join, I get a little credit. And I'll explain more in detail on the support that you get through the Freedom and Privacy Committee. I've been a member of there now for several years, and I've come to very well respect the integrity of Joe Saladino. This man, Joe Saladino, like Eddie Kane, has helped a lot of people, and because he's helped a lot of people, he became a big target for the shooters. And they went into his office, they took all his computers, they took all his files, and just literally clean clock. Well, the IRS later called back because Joe has everything encrypted, and they asked Joe for the password. Well, after Joe got off the floor from laughing so hard, you know, he had to call him back because it took a while to get his senses. He said no. And they got what do they call it, injunction for his website. Well, it's still up. He kept fighting. And he's helped a bunch of people. And he has connections, which I can't get into all his connections because I don't have first-hand knowledge. I can only assume. But he's very knowledgeable. He's a good litigator, and he's a man of integrity. And there's a lot of people in this country that are taking advantage of us. You know, like, you know, there was a thing going around, well, sue the IRS, just give us $5,000 and we'll go get them, you know, and all this. And you're going to make millions, you know. And you know, and it might be so, I don't know. I haven't seen anybody make millions yet. I've seen a lot of people give out $5,000 and later lose their house. We have a very affordable program, and we have a very well program where you get educated through conference calls, through Freedom Committee members such as myself, that it's in our blood to do what we do. We don't do this because we like to. Believe me, we don't. And you're not here because you like to be in a position that you like. If anything, you like to see it change back to the way it ought to be. And whether that'll ever happen or not, I don't know. I kind of like stand on revelations and expect that to happen and looking forward to it. But that's my belief. But going on to the Section 83, you'll see here, it'll go in detail how the DOJ has argued, and I passed this somewhere along the line, because it's hard to talk and read at the same time. Yeah, the Monsanto decision regarding any property, 3 very recent decisions deal directly with the same question as to how to interpret any. It is all inclusive or subject to degradation. The inclusion here of lengthy excerpts is intended to offer, all the input on the topic, and I'll have you read that, in your own time, because it would take a lot of time, and I'm not sure if I can explain it as well as the intent here is to put it. But you're welcome to come on the calls and discuss it. In fact, later on this afternoon, when it's about 10 or 11 o'clock in Washington, if we can, we're going to put it on a cell phone speaker and talk to Dave Maryland about the complaint. But let's move on. We get this section 83. Oh, this section 83 regarding the Pete Hendrickson. If Pete Hendrickson would acknowledge this, then that could be added to the 1099 as to why you're zeroing it out, because the 1040 form, even though there is no requirement for the American citizen to fill it out, I think it's the 255 form is the one that we should be filling out if we're to fill out at all. There is no place on the form to use section 83. So that's the problem. And being that the 1040 form is not for the Americans, people living in the 50 states, even if you did the long version, in my impression, in my opinion, you should be filling out that form anyhow. And so, learning all this and going to the grand jury, what I did with all the forms that I filled out, I did a nunc pro tunc. And I took my signatures off the form because I wanted to go back, being that I'm in front of the grand jury, I wanted to go back to the beginning. And the reason being is I can argue a lot better on a form that there's no requirement for me to fill out than I can to try to educate a grand jury what the definition of income, what the definition of employee, what the definition of all that, all those definitions. In fact, let me show you how the definitions are used against us, and not used against us in the way that they're defined, but used against us to only confuse the issue. Definitions. Okay, here's your normal definitions, which you really, you can use them in your argument, but I wouldn't really get into it because so many people have done that and they're all in prison. They use, I'm not the person defined in the code. Okay. But you're the individual, and I want to show you how person, individual, and taxpayer are, how they just turn it over. Okay, if you're not the person, then you're the individual. Or if you're not the individual, then you're the taxpayer. And the way they do it is how they're confused. Okay. To backtrack a bit, observe how the feds use the term means as in the definition of wages and employee, but the term includes in the definition of employee. This is no accident. The term means is not generally restricted throughout the entire title. as is the term includes. It is used to temporarily set aside the general restriction under include for the purpose of a particular section, paragraph, subtitle, etc. And let me skip on the point search. Okay, here, we'll just start down here. You see, for an example of this latter on the section 3402P, which refers to remuneration for services by the employee. For his employer, which does not constitute wages. How can such remuneration not constitute wages? When the federal government employee moonlights for another employee, a private sector employer, obviously, such private sector remuneration does not constitute wages within the meaning of section 3401, since the wages are paid by the employer other than the federal government. The moral of this is clear. Do not take anything in the IRC at face value. The people who wrote this are very clever, and either of us, so read it carefully many times. Ideally, its author should be rounded up and hung by the highest tree by their dangling modifiers. Okay. An individual is the same as an employee. Notice in section 3401D, definition of employer, that an individual performs services as an employee, as the employee of the employer. The IRS doesn't say any individual, it says an individual, an individual. The use of an instead of any restricts the meaning of individual to one who works as an employee for the employer, the federal government. And when I read that, I'm not good at English. I didn't, like I said, I only got a 7th grade education, so I'm learning my English and grammar now. When people write this stuff, has anybody ever seen a book? Goodbye, April 15th. Yeah.
Bob Graham's book?
Huh?
Bob Graham's book?
I don't know if it's Bob Graham's. I don't think so. It was probably some group, but it was an old book back in the pilot days. And somehow I have it, and I started reading it, and all this is out of that, and it makes a lot of sense. The way it's an individual, so they got to connect it together. And then you go down, an individual means person. And you go down here, so far, the daisy chain of the IRS definition is a federal government employee, is an employee. And the employee is an individual. The text link is the chain of deception, is that an individual is now a person. The term person shall be construed to mean the individual, to include an individual, a trust and state partnership or association, company or corporation. But you go back and all these definitions are fine, and you can say, I'll stipulate that I'm in a trade or business. I'll stipulate that I'm a person. I'll stipulate that I'm an individual. Mr. Agent, I'll stipulate anything you want to say. Anything you want to call me. Just show me where Congress extended the authority of the Secretary to the 50 states. And we don't have a problem. That's a powerful position to stand on. Because that's the whole crux. Why is it the whole crux? Well, when you read and you go down this 15-page brief here on Title 42, Section 72, Title 4, Section 72, I guess I got Title 42 on my mind because that's what I really would like to do. here is the statutes at large. Now, the statutes at large are the laws of the 50 states, am I right? Marla, isn't that correct? All laws of the statutes at large are for the 50 states?
Not necessarily, it requires them to be
Excuse
enacted.
me.
It requires them to be enacted into positive law before they reach into the 50 states.
Okay. So, here in before Title IV, Section 72, because I think Title IV, Section 72 was written in 1948, if I'm not mistaken. This was written in 1790. And it says here, which I blocked in red, be it further enacted that on said, the first Monday in December of the year 1000, the seat of government of the United States shall, by virtue of this act, be transferred to the district and place aforesaid, and all offices attached to the seat of the government. How many offices did they name? All of them. Okay, there wasn't any misunderstanding there. According to be removed thereto by their respective holders, and shall, after the said day, cease to exercise elsewhere, and that the necessary expenses of such removal shall be defrayed as the duties of imposts and tonnage, of which sufficient sum is hereby appropriated. So, I mean, it was clear from the founding fathers. And now here's the statutes at large in 1947. And this is where Title IV, Section 72 derived from. Let's see if I got this highlighted. No. Okay. 72. That comes up here. There we go. Public offices. Now, what's a trade or business? Functioning as a public office, right? All offices attached to the seat of government shall be exercised in the District of Columbia and not elsewhere, except as otherwise expressly provided by law. Is there any question about the term expressly? Now, I went through this with the grand jury, by the way. You know, and in your handouts, like I have here, any expressly delegated exception to the limitations of an officer authority of that District of Columbia and not elsewhere to be authorized by Congress and law. And one of the key words in 472 is the word expressly. This means that when Congress extends the authority of any, there's that word any. Remember in the Title 80, in Section 83, any is everything, okay? Is anything, it's there. Any office or officer of the United States outside the District of Columbia, not elsewhere, Congress will do it by expressly extending the Secretary's authority and by leaving no doubt that the authority has been expressly extended by Congress to a particular geographical area outside the District of Columbia. The definition of expressly from Black's Law Dictionary reads as follows. And basically it's the opposite of implied. Okay, I'm not implying. It's got to be expressed. It's got to be shown. It's got to be detailed where it is. Isn't that what law is about? Every word's got to have a definition, and it must be not vague, but it must be expressly provided. And so when you hammer this on them, and again, we go back to my old saying, did they run out of ink when they wrote the laws here? They did. They expressly wrote it right here in chapter 75, subtitle F of the Internal Revenue Code. It shall constitute the offense against the government of the Virgin Islands. So they wrote it for the Virgin Islands. They didn't. In all through the code, I think in chapter, somewhere in this maze, they talk about the several states when they talk about oil and gas. In fact, when they used on the notice of federal tax liens, they say you didn't pay a 1040 tax. Well, if you look up section 1040, it's about farm equipment. How many of you are in farms that have tax liens or notice of federal tax liens? See, so it's all, it's all implied, it's not expressed. Okay, so, with all being said, when you study out, and I would emphasize, please study it out. All this can be thrown away. You don't need to go to this book anymore. As many years as I've spent this book, my other book, I got, pages that are so worn, and notes all over the place, you can't read it anymore. But this book it'd be as if it was in Spain or France or some other country, their laws.
What is that book?
Title 26.
Internal Revenue Code.
The Internal Revenue Code. It doesn't apply to me. It's garbage. I mean, and that's where it's going. It's in the garbage because unless there's a law in here that I can stand on, that the secretary is authorized by Congress. Who writes the laws for this country? Congress, right? Congress writes the laws. The executive branch enforces the laws. And the judicial, assumingly, supposedly, is supposed to judge the law. Now they're legislating from the bench now, but and that's what we got to stop. And thank God for jail for judges. And that's one of the things that I want to bring up at the meeting, and I will bring it up now, is all of us can't do everything. I can't be, pounding the judges' doors and the courthouses and so forth for jail for judges. But I can encourage other people to do so. I got my own fight. I have my own gift, I guess is what you want to say, and the things that are in my heart to do, and that is what I'm doing right now, is learning how to do what I do so I can help other people learn, and together we can gain the big snowball effect and get a lot of knowledge. And for those people that think their way is the best way, and you can take the highway, take what they know, see how it can apply to you without being contrary to your beliefs. And if you put it together, for instance, like Pete Hendrickson, I want to take the time to take what Dave Merlin has put together, what Pete Hendrickson has put together, and see how I can use it to file and get the returns. Because I don't want to do the returns anymore based on Pete Hendrickson's way without putting in Section 83 in. Even though that Pete Hendrickson is right, but 83 should be in front of that first, because 83 is my property. And nowhere in Pete Hendrickson are you talking the money in your labor is your property. And that's an important fact because the Declaration of the Declaration of Independence is based on pursuit of happiness and property, life, liberty, and property. And so I need to, again, study more on that out. Now, going back to the we got the judge's order here. Now, when I went in front of the judge, after I left the grand jury on the 24th, I got the order later here that I am to be, well, that's not the summons, is it? That is the grand jury proceedings. Yeah, that's the King's Court. She gave me show cause. It was going to be in camera. Does everybody know what in camera? Does anybody know what in camera? In camera means you can't have any witnesses. It's only in the chambers. Why is it so secret? Why is everything so secret? You know, because they don't want people to know. But now, what I'm going to tell you is what I did, and I'm going to tell you also what I should have done. The minute, okay, one of the things when I got the subpoena originally to come before the grand jury, I should have, if I didn't want to go in front of the grand jury, I should have challenged the validity of the subpoena right off the bat, because like everything you do is a challenge. It must be challenged. If you acquiesce into one, then you can challenge jurisdiction any time, even on appeal. But the thing of it is, the faster you challenge, the more ground is on your side. And if you challenge right from the beginning, like I've been doing for years, under Ryder versus the U.S., now, if I'm not mistaken, Ryder did go to prison and he appealed, and if I remember right, I think that the court said if he had challenged from the beginning, you know, he probably wouldn't be in the position he's in. He didn't have a cell phone, he just had a cell. So in that we learned that you got to challenge every step of the way. So but I wanted to go in front of the grand jury, see, because I had the confidence. Some people say I had the stupidity. Well, I had the confidence. Whether it's a mistake or not, we'll soon tell. But I had the confidence that, you know, the grand jury's got to make a decision. And let me tell you, they are puppets. They are not. You have with conversations with Rick and some others, the grand jury has to be well informed. And there's some things now I know that I didn't know then. I could have had each juror stand up and ask him, what does he know of the Internal Revenue Code? You know? And I had the opportunity to find out do they live in a judicial district. I mean, I could have challenged jurisdiction right from the get-go, and maybe I should have, but I also I'm hoping that it's never that I'm arrogant, that you know I know so much and you know yada yada yada, 'cause I don't. But I do know that I know more than them about what I'm being charged with. The thing that I have to overcome is their perception, and try to overcome that with truth. Because don't forget, the U.S. attorney has got probably a stack this high of paperwork from Chris Chapman that from the IRS showing, see, we bill him, we send him all these invoices and send him all these demands, and he writes stuff accepted for value, and you know, and he has some kind of garbage on there about UCC and all this. And you know, quite frankly, I don't know if a lot of that stuff is right or wrong. At the time, it seemed like the right thing to do, and still today, it seems like there's some things about it that is right. There's some, I don't know if it's all that important or not, and that's an arguendo type thing. Because in some circles, like if you talk to Laszlo, for those who were at Laszlo's seminar a couple of weeks ago, he said, "Oh, the UCC is their paperwork and this and that, and you know, you got to get rid of your birth certificate, you got to get rid of your social security number, your driver's license, and so forth. You can't have any bank accounts." Well, you know, if you look at what would Jesus do today, would he have a bank account? I don't think so. I know he wouldn't have a driver's license, and I know he wouldn't have a birth certificate. But but can I live like that? You know, I'm still a believer. I still believe he rose and died for our sins. But you know, he wanted you to be a good. If you're a slave, be a good slave. If you're a master, be a good master. Well, I like to have my liberty, and I like to have all of it. But I can't support my family without a bank account. I can't support my family if I'm always in and out of jail. I mean, how much money am I going to make? So, with that being said, you got to take what you can do for yourself and stand on the grounds that you are firmly believe in. And one of these things in all these documents that you get here is, one is jurisdiction, the second is jurisdiction, and when all else fails, stand on jurisdiction. Eddie Kane, who is in jail, is standing on jurisdiction. He's not going to get into the argument. The facts are on the moon. He argued jurisdiction from the beginning. They went and kidnapped him out of Panama and brought him to Marion County Jail, and they got him there, and he's been challenging jurisdiction. The judge doesn't want to hear it, and the judge is going to hear it. He's going to hear quite a bit of it. And if we can get the judge in jail, that'll be a job well done. The judge has really committed some crimes now, and so we're still working on that. But anyhow, back to this. The judge had me come in for an in camera, which was something that I wasn't sure what was going to happen. This is my first time. I didn't know. I talked to a bunch of people, even before I went into the grand jury. I searched and talked to people who went in front of the grand jury because I wanted to get a feeling of what was going to happen. Well, when I got this order, there wasn't too many people to talk to. It's just, you go in front of a judge and you got to show her why you should not be held in contempt. What I did not know is that I was going to question the CID agent on the stand. What I did not know, and I didn't do, I didn't know I could have had the U.S. attorney on the stand. And I didn't know that. And the judge said, "Is there any other witnesses you want to call?" Looking in the courtroom, it's an empty courtroom. Who's there to call? And I wish she would have said, but she didn't. But I had the CID agent on the stand, which was interesting. I was so excited, and I displayed my excitement. Of course, if you mean, oh, great, here, wait a minute. And I'm running around getting my stuff. Now, it did become in camera because nobody came. See, if I knew it wasn't going to be in camera, I would have asked all of you to come, see? But it was going to be in camera. But being that nobody came except my wife and sister-in-law, now all of a sudden it's open to the public. And I said, okay, that's all right. It'll be on the record. So the U.S. Attorney calls Agent Solar on the stand, and that's when I knew, I'm going to have a chance to cross-examine. This is great. So he asked Agent Solar, his name, his qualifications, and so forth and so on. And basically, he says, well, Mr. Chapman's a resident of Cocoa, Florida. I've been to his house, and yada, yada, yada. So then when I got up, I asked Agent Solar, I said, okay, Mr. Solar, so if I understand, you've been an agent of the Internal Revenue Service, is that correct, for 20 years? And he goes, no, I'm a special agent, excuse me, special agent. I said, and you've been with them for 20 years? He goes, no, 22. I said, good, okay. So, would you say that you're an expert in the law? And he goes, well, nobody ever called me an expert before, he says. And I said, well, you know the law that you're pursuing, right? The actor. He goes, well, I've been trained, and we go for continual training. And I said, and that's for criminal investigation, isn't that correct? And he goes, well, yeah. And I said, so, and you're criminally investigating me for a tax law, is that correct? And he goes, yes. And I said, may I inquire what tax law are you investigating me for? He said, well, 7201. I said, 7201. I said, okay. Now, I didn't have my IRS book. I asked Blockhead if I could use his, and he was gracious enough to give it to me. And so, when I said 7201, I said, okay, would you mind, now I'm going to read that, so it said, I'm just going to read part of it. Excuse me. And I said, 7201 says, any person who willfully attempts in any manner to evade or defeat any tax imposed by this title. And it goes on. And I said, so is that the one you're after me for? He goes, yes. And I said, may I inquire which tax you're after me for? Because it says any tax. And he says, well, the income tax. I said, well, the Constitution has two taxes, a direct tax and an excise tax. Is it a direct tax? Can you believe it? He says, well, I don't know what a direct tax is. I said, wait a minute. I didn't expect that answer, Judge. Hold on, I got to think about that one minute. Are you telling me you're an IRS agent, you don't know what a direct tax is? And he goes, no, I don't. I said, so, well, then it can't be a direct tax, because if it was a direct tax, you would know. Or then we would all know, wouldn't we? I said, so it must be an excise tax. And he says, no, it's not an excise tax. I said, wait a minute. If it's not a direct tax, and it's not an indirect tax, what tax is it? He said, personal income tax. And I said, would you mind showing me where that is in the statute? Objection. The judge almost got up and objected. And I said, well, this is the whole foundation, Judge, on jurisdiction. He can't even tell me what tax I violated. And I'm being hammered with the grand jury and exemplars, and nobody knows why. It's a secret, even to this court. And she says, move on, Mr. Chapman. And I thought about, okay, I'm going to walk out of the courtroom, but I figured it's not. So I said, okay, and I think that we're going to change pace, and we'll go from there. Hold on.